Legal Pepper Soup, episode number 2, recorded on the 23rd of August 2016. The music is provided by Lambo the Virus, and this episode is sponsored by Kososhi Clothing and OJN Solicitors. Welcome to OJN's Legal Pepper Soup podcast. We put the pepper soup in the podcast because in each episode we dish up and serve you extra hot legal topics for your consideration and consumption. Our aim is to dissect the issues, get straight to the point, and provide you with useful legal information and advice.
It's very crystal clear like the biblical take mene you fasting.
We like to keep it simple. I am your host, Obi Wakeji, Principal Solicitor of OJN Solicitors based in Enfield Town, Greater London in England. The hot topic of today's show is European national family members and retaining the rights of residence. In what circumstances can a European family member make an application to retain the rights of residence? What are the common mistakes people make when applying? And how do you go about making such an application? Now, in the studio with me today is Lawrence Jegede. He is a qualified solicitor who specializes in immigration, civil litigation and employment. He's here to discuss this topic with us. Thank you very much for coming to the studio.
Thank you for inviting me again.
All right, now I know that there are certain situations where family members of European nationals have resided in the UK, and due to one thing or the other, certain circumstances occur in which they are able to make an application to retain their rights of residence even though they're no longer with that European national per se. Like maybe the European national is not in the UK or something has happened to them. Or can you just kind of break down and explain to us the different types of circumstances in which may arise and somebody can make an application?
Yes, that's fine. There are situations whereby a family member of a European national person should be able to retain their right of residence. I'll be focusing on about 3, 4, or 5 categories. And the first is where a family member of an EEA person is able to retain their right of residence because the EEA national person has died. The second one is where the EEA national person has died. The child of that EEA national should be able to retain their right of residence. And the third one is the parent of the child of the European national person who has died, also because of that child should be able to retain their right of residence. And then you have another situation where divorce has taken place, marriage is come to an end, there's been termination of marriage. Some people who find themselves in that situation as well should be able to retain their right of residence. Those are the 4 key scenarios that we can find in this.
Okay, thank you for breaking it down to us like that. Now, the first one I think you did mention was a European national member. Sorry, the actual European national has died.
Yes.
What happens in a situation like that, and in what circumstances will they be able to then make an application to retain the rights of residence?
So we have a situation, for example, where the European national has come to the UK, has lived in the UK, has worked in the UK. Again, that would be that person has been exercising their treaty right, but let's say about a year or 2 years after that, the European person has now died. But before that, they lived in the UK with a family member, for example, their wife or their husband. So even though that family member has not obtained permanent residence card yet, that person in that situation should be able to apply for retained rights of residence. And the requirement for that is, first one, of course, is they must be able to prove that they've been a family member of the European person who has died and that they've lived in the UK in accordance with the European regulations for at least a year before the death of the European national.
1 year.
1 year before the death of the European national, and that they've been working, or they've been self-employed, or they have been self-sufficient person in the UK. And the last requirement is the European person before their death must also have been exercising treaty rights in the UK. What that really means is that the European person must have been working or been self-employed, a student with comprehensive medical insurance, or a self-sufficient person also with comprehensive medical insurance.
Okay, just to clarify one thing in relation to the European family member, do they have to be working as well?
The family member also must be working or self-employed, or if this family member can say, I've not been working, but I've been a self-sufficient person and I have my comprehensive medical insurance, then that person should be able to satisfy the requirements of the regulations.
Okay, thank you. You then mentioned a child of the European national, and you also mentioned the parent of the child of that European national.
That's correct.
Where do they stand in this?
Anybody finding themselves in that situation also should be able to retain their right of residence. So again, for example, the European national has died, or in this case has decided to leave the United Kingdom. They've stopped living in the country, they've gone back to their home country, or they've gone to another country perhaps. Now, the child of that European national should be able to retain their right of residence even though they haven't lived in the UK for 5 years before qualifying for permanent residence. What that child will be able or should be able to satisfy in order to retain their rights of residence is to show that, of course, the first is to prove relationship, that they are the child of the EEA national, and that when the EEA national died or ceased to live in the UK, that child was in education in the UK when that at the time of death or cessation of living in the UK. Those are the key requirements for a child, really.
Okay, so can I just ask, is there a minimum period that they must have lived in the UK before they can make this application to retain their rights of residence?
As far as the child is concerned, there is no requirement in relation to residence. All the child needs to prove is to show that they've been in education, they've been studying in the UK. That's what they need to prove. It may be for months, it may be for years. What the key requirement is education in the United Kingdom.
Well, they must have been educated in the UK. And
That's
what's the position in relation to the parent? Because obviously the child, it sort of makes sense because the child can't be left in the UK on his or her own.
Yes.
So the parent will then be able to make an application to retain the rights of residence. What is that, while the child is still in education?
While the child is still in education, you see, a child who is able to satisfy the requirements that I just mentioned about the EEA nationals died or has ceased to live in the UK, the parents of that child should also be able to retain their rights of residence. So again, there is no requirement about length of residence. That parent does not need to show that they've been living in the UK for a certain number of years. All they need to show is, I am the parent of this child who has been able to retain their rights of residence because the EEA national, the parent, has died or has stopped living in the UK.
All right. What other scenarios exist again? You did mention divorce,
Yes.
relationship breakdown.
Yes.
What's the position in relation to a European national who's married and their relationship has broken down?
Anyone finding themselves in that situation shouldn't be overly worried. As long as they can satisfy these requirements that I'm about to outline, they also should qualify for retained rights of residence. And the key requirements really are that they've divorced. And when I say they've divorced, divorce must have taken place completely. It is not just the start of proceedings of divorce. There must have been termination of the marriage. Some people make mistake whereby they've just started the divorce proceedings and they think they can make the application. No. So divorce must have taken place. The other requirement is they were living in the UK. The family member must be able to show that they were living in the UK at the time of divorce and that they've been married for at least 3 years before the start of the divorce proceedings. Now that is key. You must be able to show that you've been living for at least 3 years before the start of the proceedings, not during the proceedings of the divorce, not after the divorce proceedings, but at the start of the divorce proceedings. You must be able to show that I've been living in the UK. That you've been married for at least 3 years. In regards to residence, you must be able to show that you've been living in the UK for at least 1 year. And also, I must say, you must have been working as well, or self-employed, or self-sufficient person, again with comprehensive medical insurance. And also, your EEA national spouse must have been exercising treaty rights during the period of your residence in the United Kingdom. So that is what I would call the first subcategory in this under this heading. The other one is if you have custody of your child, the custody of the child of your relationship with the EEA national, while the divorce is already taking place, by the way, that one anybody in that situation should also be able to retain their rights of residence. Or if you have access order to the child, Again, after the divorce is already taking place, the EEA National has exercised treaty rights in the UK. You've also worked on being self-employed or being a self-sufficient person with comprehensive medical insurance. You should be able to qualify for retained rights of residence. And the final one is people who have been a victim of domestic violence during the course of their marriage. And after the marriage is broken down, they also should be able to go to the Home Office with an application and say they want to retain their right of residence, even though they haven't lived in the UK for 5 years, in order to obtain permanent residence.
So what is the criteria for victims of domestic violence?
The criteria really is not always that very straightforward, you see, but it is advisable to have some form of documentary evidence to show that you've been a victim of domestic violence. And what we advise people to do and to obtain is, if you experience domestic violence, make a report to the police. Then you should be able to get a police report or sometimes a memo from the police to confirm that you've made a complaint of domestic violence to them. And in the UK, there are organizations, associations who help advise victims of domestic violence. If you make contact with these organizations, some of them they will write you a letter, some of them they will send people to you, some of them they will invite you to their offices for counseling. Any documentary evidence you can produce in relation to your contact with these organizations, those documentary evidence should be able to satisfy the Home Office that it is true that you've been a victim of domestic violence.
Does the European national member have to also have worked?
The European national member must have worked, or been self-employed, or being a self-sufficient person with comprehensive medical insurance.
That's essentially exercising their treaty rights.
That is a family member. The EEA national, during the period of marriage,
Yes.
before the breakdown of marriage, must have exercised treaty rights.
No, I don't mean before the breakdown. I mean in relation to the domestic violence context in which you spoke about now. Does the European national have to be exercising their treaty rights, i.e. working and such?
Yes.
All right, now one common problem or thread that runs through the heart of many of these cases in relation to retaining the rights of residence is if your relationship has broken down or the European national member has left the UK or has died, how can the European national family member go about by providing evidence that the European national member was working? I mean, if a relationship has broken down, it's quite common to see that the other partner will not cooperate in any way by providing their pay slips or bank statements or evidence of work. How does the European national family member go about this? Because it seems to be a common thread that runs through these applications that before you can get any level of success, you have to show that the European national was working.
What you can do is to write a letter to the Home Office, explain the situation to them, and in fact ask the Home Office to make inquiry with the HMRC to request for the evidence of tax payments or national insurance contributions made by this EEA national.
Wait, hold on a minute. You're saying that an applicant can actually write to the Home Office and say, can you make inquiries on my behalf in relation to the European nationals?
That's correct. That is something that we've come across before in my practice, and in fact I've been engaged in a case like that before where we just could not produce any documentary evidence. This other person, the EEA national, has disappeared. We made inquiries to locate their whereabouts. We couldn't get any confirmation as to their whereabouts, so what we had to do was to write to the Home Office to explain the situation to them, and we said, but we're sure that this person has worked in the UK for the last 2-3 years, but we've been unable to provide any documentary evidence in that to that effect for this reason and for that reason. Could you write to the HMRC? Because if you yourself write to the HMRC, they're not going to provide any information to you about another person.
All right, because of the Data Protection
because
Act.
Because of the Data Protection Act rules and regulations. But the Home Office should be able. Now, the Home Office, they might not want to cooperate with you as well, but you just have to do what you have to do. Write to them, explain the situation to them, request them to get in contact with the HMRC to disclose to them relevant document in connection with the employment or self-employment of the EEA national.
It seems to be a bit far-fetched that the Home Office would actually respond. Would they? Would they respond?
That's correct. You see, they might respond, they might not respond. But as long as you have discharged that duty that I've done what I had to do, try to get these documents to show that the EEA national person has worked in the UK, I've not been able to get it. I've contacted the relevant authorities to obtain this document. That's all you have to show as far as you are concerned. So as long as you've done that, whatever happens after that is really out of your control. But in case the matter goes to the tribunal, then you can satisfy the tribunal that you've been in touch with the Home Office. They should have done what they should have done. Yes.
All right, so if it does go to the tribunal on appeal, so say for example you've made the application, the Home Office don't conduct the inquiries and they refuse it.
Yes.
If it goes to, there is a right of appeal, isn't it?
You should have right.
You should have a right to appeal.
Yes.
Now you go to the appeal, and you explain and you show evidence that you've contacted the Home Office to provide evidence
Yes.
that the European national was working.
Yes.
The Home Office have refused to comply.
Yes.
And would that go against the Home Office?
It should go against the Home Office, because going to the tribunal, you actually have a good ground to stand before the tribunal judge and say, because the Home Office should have access. Even if they don't, they can get this information, because you have to also realize that these governmental authorities, they work centrally these days. So whatever information the HMRC have, it's possible for them to pass it on to the Home Office. The Home Office can easily get that information from them. So if you go before the tribunal, you explain that to the tribunal, it is very likely that the tribunal judge will agree with you.
Okay, now in relation to making an application, what is the procedure to make an application for any of these, in any of these circumstances? What would you do?
Given the quite complex nature of this type of applications, I would advise anyone who is thinking of making this application, or people who find themselves in this kind of situations, to seek specialist legal advice from law centers, citizen advice bureau, and their local solicitors before they make this kind of application, because it is very easy to get it wrong, and you don't really want to get it wrong. Again, as I said, this kind of application, they're quite complex, and you want to make sure that you get them right. They're not as that very straightforward as someone who is applying for residence card or permanent residence card. This one is a deviation from those two categories. So going to what do you do to make to apply for retained right of residence? Get the relevant documentary evidence in relation to the information that I've already given. For example, any evidence to show that this EEA national has died, that will be the death certificate. Evidence to show that you have worked in the UK or you've been self-employed, that will be pay slips, letter from your employer. And the same thing applies to the EEA national. Evidence to show that they've also exercised their treaty rights in the UK, pay slips, letter from employer, contract of employment, proof of self-employment, such as their self-assessment tax return forms, proof of national insurance contributions. If they've been self-sufficient, of course, prove that they have enough resources to maintain themselves in the UK, their bank statement, money they have in their savings account, and also comprehensive medical insurance. So you have to have all these documents, and also documents to show the length of residence you've accumulated in the UK. So get all the documents together, complete the application form. There is a fee payable of £65 to the Home Office. Again, as I said, seek specialist legal advice. Once you have all these things ready, then you're good to go. Put in the application to the Home Office and wait for the decision.
Okay, brilliant. That's really been interesting. Just to summarize, there are certain categories in which you said that a person can make an application to retain the rights of residence. You mentioned a situation where the European family member has died, if they've lived in the UK for a year, if the European national was working and the European family member was working, they can make an application.
Yes.
You've mentioned the child of a European national, or the parent could make an application to retain the rights of residence where the European national is away or not in the UK.
Yes.
The child has to be in education.
The child has to be in
That's
education.
the main qualifying thing. So
yes,
to provide evidence for that, you'd probably provide school
you have
reports.
to provide your school report letters from the school.
You also mentioned divorce, where the requirements there would be that the marriage must have lasted for at least 3 years.
Yes.
They must have lived in the UK for more than 1 year.
Yes.
And the marriage must have been terminated.
Yes.
And it's not at the start of the proceedings, it's at the end of the proceedings.
It has to be at the end of the proceedings before you can make the application.
And you finally, you mentioned victims of domestic violence, where somebody has been a victim of domestic violence.
Yes.
They can make an application to retain their rights of residence if they provide the requisite evidence in support of that application.
Yes, that's correct.
Thank you very much indeed for taking out your time to impart this knowledge and information in relation to this topic. So that's it from the Legal Pepper Soup podcast. Thank you all for listening, because without you, the listener, there is no podcast. Please drop us a comment to let us know if you like the show, what we could do to improve, or what would you like us to discuss in future episodes. You can find us on Facebook, search Legal Pepper Soup, on Twitter at Legal Pepper Soup, or visit our website /blog legalpeppersoup.com. If you would like specific legal advice on any matters discussed on this show or in general, please call 0203 232 2135 or 07587 132 604, quoting Legal Pepper Soup. I am Obi Wakeji signing out, and remember, ignorance of the law is no excuse.